This is PwC Trend Talks. My name is Mark Lautier, and today we'll be hosting a special edition of the Trend Talks relating to GDPR. It has now been 4 years since the coming into force of the General Data Protection Regulation, a regulation which, although not revolutionarily, at least from a principles point of view, clearly has given much more importance to this subject. With us today to discuss all matters data protection, we're lucky and pleased to have Mr. Ian Deguara, the Information and Data Protection Commissioner. Ian, welcome.
Thank you for inviting me for this podcast. I believe that now we have had GDPR for 4 years since the regulation came into application, and it is important as well for individuals to be more aware about their rights. Even though we have seen a steady growth in awareness, I would say that still there are many persons who still do not consider themselves as giving that importance or that much importance to GDPR as much it deserves. Because at the end of the day, here we are talking about a fundamental right, our fundamental right enshrined in the EU Charter, and it is something which should be given priority, in my view.
Thanks for that introduction, Ian, and we'll surely come to those points. But I think as a first thing, it's good to hear a bit about Ian and who you are. You've been 2 years as Commissioner, but I understand it's been like 20 years at the Office of Commissioner. Yeah. I'm really intrigued to know what brought you into this area, and even more, what has kept you into it.
It's a very important question, very interesting question actually, because even I, to myself, I ask that question every day. And the reply I get is that, I have a passion now for the subject. And that is what kept me in the office for all these years, because I was one of the first employees to join the office way back towards the end of 2002. At the beginning, when I joined, it was something new for me. So when I saw the vacancy at that time after finishing my university degrees, I thought, what is this about? It was something new at the time, and I decided to join. I was selected, and when I joined the office, there was actually very few people there. There was a new law which was in the pipeline of being adopted at the time, because the Data Protection Act, Chapter 440 at the time, was still not brought into force, so it was still a draft. And there was also a number of regulations which were in the pipeline to be adopted. And so my first tasks at the office was, because we have a very close relationship with the UK, so to go to the ICO's office, a website at that time, and see how they are set up, to see what guidelines they issued at the time, how they have implemented the notification requirements, because that was something which was going to be enforced, the complaints forms, the query forms. And so my first task were to actually see all these things and develop a website containing the necessary information to start. Then when the law comes into force, then we go out and say, look here, we exist. There is this office now, a data protection office. This exists. Something funny, for instance, is that when I used to tell people where I work, the impression was that we were that kind of office which held all the information about the government. So, yes, you work there, you have access to all the information now. Contrary to all that, we have never had, and even until today, we have no access to any data. So we actually are the regulators in order to ensure that controllers, so those companies, organizations which process personal data, do indeed comply with the requirements of the law, and also to provide a remedy to complainants who feel that they might have suffered a potential infringement of their rights.
Thanks for that. But your role is not just data protection. We read about freedom of information, AI, and all that. Can you just give us a bit of an overview of what else a day in the life of would look like?
So our remit is not only limited to data protection. Primarily, it is data protection, but we also enforce freedom of information laws, and until a couple of months back, we are also the regulatory body for the reuse of public sector information. I have to admit that the bulk of the work comes from data protection complaints and issues, but still, freedom of information is picking up a lot because if I were to compare certain statistical figures, for instance, whereas like 5 years ago, we used to receive 15 complaints on an annual basis. In the past 2 years, they went up and shot up to 80, even 100 cases per year.
What does that bring from a team perspective? So how has the team grown over the years?
Our team is mainly composed from lawyers. We have the legal team.
Which is a good thing.
Of course, because you are a lawyer, so I mean, you are in favor of lawyers. And we have the technical people. So my colleagues work on both pieces of legislation. So they investigate both cases of data protection and also investigate cases in relation to freedom of information legislation. The technical guys, until today we have only 2, but we are in the process of recruiting more people, both lawyers and also technical personnel. The technical people mainly deal with personal data breaches. So their task is to investigate personal data breaches which are notified to our office, and they try to establish all the facts and gather all the information from controllers for the purposes then of issuing a binding decision depending on what is established during the course of the investigation.
So I guess your role is not just data protection, but it's besides the technical part, there is the team, the recruitment, the oversight and all that.
Yes, indeed. So a day at my office is quite full, I would say, because in my role, I am actively involved in the investigation of cases. Since we are a small office, I mean, that brings a number of advantages. I believe in a flat design of organization. In fact, we have a flat design, flat organization in terms of structure, and everyone is responsible for the area on which he or she is working. Although my colleagues have certain specializations, I mean, there are lawyers, there are technical people. However, I believe that they also have to be generalists in the sense that when we receive inquiries, for instance, or when we are requested to, deliver presentations, awareness sessions, or participate in meetings locally or abroad, I mean, they will still have the general oversight or general understanding of what's happening. So both in terms of both legislations.
I think, Ian, that's a very important thing. In the sense, something which I find distinguishes Malta from other jurisdictions is the fact that the authorities are there, first and foremost, to apply the rules, but at the same time are there to also explain it and make sure that businesses understand what it implies. We're speaking about data protection and the need to, make sure that you have the processes there in place, but it's at the same time explaining it and helping them to achieve those levels of protection that we need.
Yep. Also, from my experience as well, people, data subject, but also controllers, notwithstanding the fact that we have a lot of guidelines out there. I mean, we have developed some guidelines, but since the coming into application of the GDPR, we have decided that since the EDPB, the European Data Protection Board, regularly issues guidelines on the interpretation of certain aspects of the regulation, we do not believe that we should replicate those guidelines. Those guidelines are very exhaustive. During the deliberatory process, we are part of the board, so we give our feedback, we adopt those guidelines collegially with our colleagues. So I don't believe that we should replicate those guidelines. But what I was going to say is this, that notwithstanding having all this information, individuals, citizens, but also controllers do still want to have that personal touch or personal contact with the authority, and that is why we still receive inquiries or calls, asking us certain questions which are fully included in these guidelines, particularly from controllers, I would like to stress, on CCTVs, on other areas of the legislation. But still, that element that we are an open door policy office, and we are approachable, and we try to reply as fast as possible. So to inquiries, I make it a point that we reply within 48 hours, 72 hours max. So I believe that is a good thing because we still show that we are present. But at the same time, I believe that this kind of information, which is publicly available, should be explored more, read more, because it is something which we as European Data Protection Board, spend a lot of time developing. And this gives out the interpretation what we are expecting from controllers. So, because guidelines create a level of expectation, and therefore we are bound. So when we issue guidelines at a DPB level, it means a lot, because that would mean that whatever is written there, we have to implement. We cannot diverge from those guidelines, because that will be in breach of certain principles, of legal principles, particularly the one of legal expectation. So we cannot diverge from those guidelines, and that is why I encourage controllers in particular to have a look at the DPB website regularly, because we work a lot within the structures of the DPB in terms of expert groups. My office, we try to participate in all the expert groups within the DPB, and the guidelines which are developed provide for comprehensive guidelines which should be used, in my view.
No, I think it's a very relevant point. I think first and foremost, your first comment was something which I totally agree with, very available, very approachable, and very helpful. But I think even these guidelines and all that are helping us, because at least there's an element of alignment between what we're saying is aligned with what the commissioner, what the office would be interpreting it and also looking at. So that's fantastic. I think I remember you saying that GDPR wasn't really a revolution, it was more of an evolution. And I agree with that from a concept perspective, but clearly there has been great help in elevating data protection and privacy matters. What do you bring that to? Is it the 2 years that were there to create that awareness? Is it the fines element? Is there the communication between, the office, consultants and businesses? What would you give it, assign it to?
I would say that the GDPR has raised the bar, actually. So, whereas before, because the impression was that data protection rules came about with the GDPR, which is not the case. Other member states, apart from Malta, have had data protection rules from the 90s, mentioning Germany, even from the 80s, Germany, the UK, the Nordic countries. So, I speaking from a national level, before I don't believe that there was that much attention to data protection. GDPR was a game changer, and I can attribute it primarily or mainly to the level of fines. Because that was one of the main concerns which drove many controllers, many businesses crazy at the time, because when the GDPR was published, when it came into force on the 25th of May 2016, the first thing which was given a lot of attention was the level of fines, because it was establishing a maximum of 20 million or 4% of the annual global turnover. It comes to undertakings. So it was given a lot of importance because of that, in my view. When we used to say it was not a revolution, but an evolution, the primary reason is that the principles, the legal principles, if you were to compare the lawfulness of processing, so Article 6 and Article 9, when it comes to personal data and special categories, and Article 5, the principles of processing, and you were to compare the ones presently in the GDPR with those of Directive 95/40, you will see and observe that, in essence, they are largely the same. The same principles are there. Why? Because they are technology neutral, and they have worked. They have withstood the test of time, I would say, because since 1995, they have withstood the test of time, and they were still incorporated in the GDPR. One might argue that the GDPR have created additional burdens. I don't agree to that kind of assessment, because in my view, the GDPR has giving the individual citizens more control to their personal information.
We'll come to that, Ian.
Yeah.
But the question is, you look at the fines that were issued. There were some hefty fines from all these, contexts, but we don't have the level of fines that you read about abroad, Was that because of maybe the level of maturity with regards to Malta, the data subjects' awareness of their rights, or is it more the type of businesses that are working in Malta?
I think you're right on that. Usually we hear in the media news the big fines imposed by other supervisory authorities, by our counterparts, which mainly are imposed on big tech companies. We hear about fines imposed on Facebook, on Amazon, on other big tech multinationals. In our case, we do not have those big tech multinationals, so we do not have the luxury, or I don't know whether it's a luxury or otherwise, of imposing those levels of fines. But when it comes to determining the quantum of a fine, which has to be proportionate, effective, and dissuasive, we have to take into account a number of elements. I mean, it's useless having or being of the understanding that, okay, we can impose a 20 million fine because the GDPR provides for a maximum of a 20 million fine. When we are dealing with a small enterprise, we were discussing this before, Mark. We were saying that regardless of the size of the organization, what matters is the data which is being processed, because it might be a large organization, but the personal data which is processed is limited to basic personal data. Whereas you can have, on the other hand, a micro enterprise, a startup, a small enterprise, which processes special categories of data on a large scale. So, I mean, we have in our assessment, whereas we take into account the conditions of Article 83, the gravity, the categories, whether there is a negligent intent and all this stuff, the level of cooperation with the supervisory authority, we take into account all these factors. We also have to take into account the size of the organization. Something which is important is that the DPB has issued guidelines on the imposition of administrative fines. So it is currently publicly available. It is open for public consultation. And then after, I believe it's a 6-week period, then we will finalize the guidelines at the DPB level on the basis of the feedback which we receive, and then they will be adopted. But we are, even in those guidelines, we are establishing certain thresholds. So it's because the tendency is that someone might say, look here, the DPA in Malta is not imposing high fines. But it's not the case, because we have to take into account the size of the organization, the turnover, because in certain instances we request the turnover. And then after taking into account all those elements, then we decide and determine the level of the fine.
Valid point, very valid. And taking you back to the burden point, I think I remember early when, we started webinars, when there was the pandemic broke and we started our first sessions, we had one relating to data protection. One of the comments was like, at the moment, it's pivotal and what is of priority for us is to keep our business going. Why are you talking about to us about these matters? I think if you look back, you see that over the last few years with GDPR, and then, the Brexit, with Schrems and all that, there's been quite a number of data protection principles which have changed. And also the way we do business which have changed. Remote working has today become a norm. So this balance is something which we struggle, and I think businesses will struggle. Do you have any comments and advice to businesses on this point?
Yes. With the pandemic in particular, certain business models had to change. Had to change because either they had to go online on the one hand, and on the other hand, employees had to start working remotely. The balance in that respect was how to ensure business continuity in the light of the pandemic, but also to ensure that we keep the data secure. Because when you go online, when you provide the service electronically, the risks increase. So, and now we know that people with criminal intent, hackers in particular, have taken advantage of the pandemic because knowing of this fact that the businesses had to go online, they tried to find certain vulnerabilities in the systems in order to make certain attacks and, conduct or penetrate the system and ask for a ransomware attack. And unless you have the necessary safeguards in place, then what will you do if, for instance, you do not have a backup of your data?
And data today has become one of the most valuable items and valuable assets of a business. So
it is indeed, and that is why it is being attacked. Whereas before, people used to rob banks, for cash. Nowadays, people are going online. Hackers are going online. Criminal people are going online to steal data because data has become valuable. Yes, data has a value. So this is why, and it is important that security is placed on top of the business agenda, in my view, because particularly cybersecurity, in order to ensure that the necessary safeguards, both in terms of technical safeguards and also organizational safeguards, are appropriate to the risks which the organization is facing, depending on the nature of the business and depending on the categories of data which are being processed.
No, totally agree. And we sometimes talk about, cyber risks, which are becoming more and more of a reality. But the truth is it needs to be a fully fledged approach to security, especially when you have such a valuable asset. So, we speak about emails, we speak about USBs, we speak about, home printers, we speak about a number of minor aspects, which could, however, have big ramifications. So thank you for that point. We have to go back also to Brexit. We're hearing a lot about, at the moment, there's the adequacy decision, so all fine. But we're hearing a lot about the UK trying to start thinking about more of a business mindset and starting to introduce aspects to help UK businesses. What does that mean from a Malta business perspective?
Well, going a little back in time, we had a referendum. There was a referendum in the UK. The majority of people voted for Brexit. I'm not going to enter into the merits of the manipulation and of the disinformation campaigns, because this is something which is also important from a data protection point of view, and the use and misuse of data, which is certainly pivotal and which have had an impact both on the Brexit referendum and also on the US elections. These are well-known facts. I'm not saying something which is innovative or new. But when it comes to Brexit, currently the UK have adequacy. So data can flow from the EU to the UK on the basis of the adequacy decision. Last week, and it was expected, during the Queen's speech, which wasn't delivered by the Queen, but was delivered by Prince Charles, Prince Charles actually announced that the UK will be issuing a revised data protection legislation, which will be, as you said, Mark, quite correctly, more business friendly. We have to see what does that mean or entail. Less bureaucratic, less complex. We have to see, because the draft text will be available most probably during the summer or before the summer. What impact might that have is with regard to the adequacy decision, because it is important to mention that for the first time ever, the European Commission in the adequacy decision has inserted a sunset clause. This was the first time to introduce such a clause. Sunset clause is that the adequacy decision is valid for 4 years. And then it will be reviewed, and then depending on the outcome of the evaluation, the Commission will decide whether to renew the adequacy or otherwise. But still, even within the adequacy decision as well, there is what we call like an emergency brake. So if the Commission, even during these 4 years, will become aware, either through sources or through its own assessment, that the UK has deviated from what has been agreed during the negotiations, and therefore that, because before the UK was a full member state, and so their data protection law was almost mirroring the GDPR, so there weren't any problems in that regard. But the Commission said in its adequacy decision that if the UK deviates from those set of rules, it might trigger that emergency brake. Emergency brake meaning that it may suspend the adequacy decision. And that will, yes, have an impact on the data flows to the UK. And we know that we, Malta, have many companies which transfer data to the UK. So without an adequacy decision, it will be more burdensome because they will need to find an additional transfer mechanism under Article 46 on the basis of which to legitimize the transfer of personal data. So we have to wait and see the draft text of the new proposed legislation in the UK and see what will come out of that text. But I am pretty sure that if something will raise the eyebrows of the bureaucrats in the European Commission, something will happen. So it won't go unnoticed for sure.
Thanks for that. From a sort of to conclude, because I think we've been at this for far too long, and the initial concerns were, will we find time to fill up this session? But I think we've discussed quite a few interesting things. I think looking forward, what do you sense is there in the future for data protection? What are your comments? We know there are the SCCs, and we've been discussing something relating to third-party beneficiary rights. What are your sort of concluding comments relating to what the future holds?
There is an important conference in June, in the mid of June, which is organized by the European Data Protection Supervisor, and the name of the title of the conference is The Future of Data Protection.
There's also the PwC Tax Conference in June, Ian, so
yes,
quite a number of interesting conferences.
Yeah, so it is interesting to see what will come out of that conference. But the main issues which are known to many, at least in the data protection sphere, in my view, are two. Whether the GDPR should be amended, and we know from the 2020 evaluation report from the Commission that at least 2 years ago, the Commission decided or based its decision on the evaluation that at that point in time, the GDPR doesn't require to be reopened for discussion and to be amended. The next evaluation will be in 2 years' time. So we will have to see in that regard what will happen. But in the meantime, there are certain voices, at least at European level, which are saying that the rules are, although they are technology neutral and they have withstood the test of time and all these things, that they might need to be revised. The second point is on where data protection will go in the future, particularly, but this is something which affects us as regulators and which we are criticized about, particularly by certain NGOs that are mentioned. And OYB, I mentioned because, they publicly state all these statements. That they say that the one-stop shop mechanism is not working. So that is the claim, because there are a number of strategic cases which have not yet been decided and which are very important. So after 4 years, they have not been decided by the lead supervisory authority. And so not only by them, but even within other quarters, we most probably during this conference, there will be discussion whether this one-stop shop mechanism should change rather than a system where there is the lead supervisory authority and there are the concerned supervisory authorities. So the lead will be where the controller has its main establishment, and the concerned will be, like, for instance, where the complaint has been filed. So this is how we work for consistency cases, for strategic cases. So the argument is whether there should be a centralized body to take care of these strategic cases, and therefore there will be a speed up in the resolution of cases, whether there will be more effectiveness in terms of resolution and corrective action. So this is something which is on our plate at this moment in time to see what will happen. If you were to ask me personally, I would say, but because I do not want to create any ripples, but I believe that the system works. What needs to be done is for us as authorities to cooperate more effectively. That is the scope why we had the Vienna meeting in April this year, in order to discuss between us regulators, and we have issued a statement in this regard, how we can be more effective in terms of ensuring more effective cooperation. Because by being more efficient in our cooperation, these kind of cross-border cases might be resolved in a quicker period of time and in a more effective way. So these are things on the horizon, not in a very distant horizon, but these are the two things which in my view might change the European data protection law in the near future.
What's clear, Ian, is that there's a lot of material to have more of these PwC Trend Talk special editions, particularly covering GDPR. Once again, I thank you, Ian, for your time, and I'm sure our listeners and myself have really enjoyed this discussion.
Thank you.